Peter Allen was an important figure in Hong Kong. He was a former commissioner of the ICAC from 1991 to 1992. He died at the age of 47, which is of a heart attack, which is very scary because I'm older than that. And so I need to take care of my health, I know. Before his being a commissioner, he was an important government lawyer, and he was a Crown solicitor for 3 years. And after his passing, government lawyers and law firms pooled together their resources and created this fund that the University of Hong Kong now manages for the best and the brightest in the world that focus on public law, a topic that Peter Allen was very much committed to during his career and to his lifetime. So I want to just take this opportunity to remember him as this fund was established. Our guest of honor tonight is Professor Andrea Bianchi, who specializes in public international law, very fitting for the Peter Allen Memorial Lecture, which is actually the most prestigious public lecture that we have at University of Hong Kong. Professor Bianchi is the full professor of international law at the Graduate Institute of International and Development Studies in Geneva, now called, I believe it's the Geneva Graduate Institute. But more importantly, from my perspective, he's not only full professor there, he's my professor. He was my professor when I was doing my PhD studies and was instrumental in shaping the way I teach, and especially his playful nature, his playful intellectual nature of asking questions and exploring. And I've tried to mimic that in my own teaching. So I personally want to say thank you. It's nice to have him come and visit. And I think it's a great honor that you would come all the way from Geneva. So thank you so much for accepting this invitation. Professor Bianchi has amazing publication record, amazing CV. And on the advertisement for the lecture, you can read the list of amazing books that he's written. His most recent one here, Demystifying Treaty Interpretation, which just came out this year. Amazing book. We have it on order. He was kind enough to mail this to me, but you can order it online. You can get e-copies as well too. I highly encourage you to buy it because it's really a groundbreaking look at treaty interpretation, unlike any book really on treaty interpretation, I think, and certainly the most important work on this topic for at least 15 years. He has a PhD from Milan, University of Milan, a LLM from Harvard, and again, a wealth of knowledge and experience. But I would have to say he's, even though he's super impressive on paper, he's even more impressive in person. And so I'm very grateful that you were able to come. So thank you very much. Please join me in welcoming Professor Bianchi. So I'll reserve time for the end for questions. I would ask that you keep your questions until the end. And also, if you have a cell phone, just be sure that it's turned off. With those two caveats, time is now yours, Professor Bianchi. Thank you.
Thank you so much, James, for this very nice and generous introduction. Who says that to worry about lecture titles is an unnecessary concern? Lecture titles are very important, and when I had the honor of being notified that I was going to give the Peter Allen Memorial Lecture at the University of Hong Kong, almost immediately I had an intuition about what I wanted to speak about, and I turned it into words, the words in the title. Now, the title has three prongs, meaning, treaty interpretation, and musings. Let's touch upon them briefly in turn. So a fairly obvious example of how we as international lawyers deal with meaning is interpretation. By interpreting, we attribute meaning to the law, whether 1/6 meaning constructs it, makes it, or whatever else is open to question, but there is no doubt that lawyers are often taken up with meaning. In fact, interpretation is everywhere in law, so that to some legal philosophers, law is nothing else but interpretation. Little wonder that as an international lawyer, my main object of investigation is treaty interpretation, the second prong of the title. That is the interpretation of the agreements that states make and that constitute the main source of international obligation. When we international lawyers think of treaty interpretation, our reflex and bias is to conceive of it as rule-based, as a rule-based activity. The text of the treaty provision becomes the object of investigation to be subjected to the application of the rules of treaty interpretation as codified in the Vienna Convention on the Law of Treaties in Articles 31 to 33. Its meaning will be unveiled, brought to the surface, and revealed by applying a set of rules. The most important one of which is the general rule of interpretation, Article 31, that we, as international lawyers, all know by heart. Right? A treaty has to be interpreted in good faith according to the terms in their context, the ordinary meaning of the terms in their context in light of the object and purpose. And that's what most of the time treaty interpretation is about for both academics and practitioners. That's the state of play. By and large, however, the most interesting prong of the title, at least in my view, is the one that sounds least legal, musing. That is certainly not a word which we are tempted to associate naturally with the legal craft. The lawyer, craftsman, is supposed to learn skills and to apply them. No further reflection is asked of her. Musing, that is reflecting, thinking, thoroughly, deeply pondering, cogitating, meditating. What matters is not so much the object, but the activity in and of itself. Thinking, the time and intensity you devote to the exercise of thinking. Musing is a free space only partly constrained by professional and disciplinary protocols. And it is a tremendously useful way to free ourselves from the shackles of imparted wisdom and traditional thinking. And the tendency to look down at musings and the likes of it is a symptom of the much more widespread disease in contemporary culture, which transcends the state of international legal scholarship. I'm referring to the tendency to devalue whatever international intellectual activity is unlikely to produce some kind of material or economically valuable effect. In a wonderful little pamphlet entitled The Usefulness of the Useless, an Italian literature professor, Nuccio Ordine, reminds us of the importance of learning for its own sake. Drawing on an impressive number of sources on different epochs, the author underscores the importance of research without any practical utility, but rather for the sake of freeing humanity from the shackles of materialism and to make us ultimately more free. The book echoes and duly acknowledges Abraham Flexner's well-known essay, The Usefulness of Useless Knowledge. Now, Flexner was the first director of the Princeton's Institute of Advanced Studies, the man who brought Einstein to America. And Flexner wrote most of the really great discoveries which ultimately proved to be beneficial to mankind had been made by men and women who were driven not by the desire to be useful, but merely by the desire to satisfy their curiosity. Accumulation of useless or theoretical knowledge allows inventions and discoveries. And this is why institutions of higher learning should be devoted to the cultivation of curiosity, which I know is not a very popular claim to stand up for in contemporary culture, but that's what I think. And yet, I would add, we need to see musings on the law and the practice of the law, not necessarily in juxtaposition with each other. Musings are not just intellectual exercises for their own sake. They are actually meant to enhance the practitioner's knowledge of the interpretive process in all its elements, with a view to making them more skilled players in the game of interpretation, by helping them to see relevant factors and connections that someone who sticks to the traditional rule-based approach to treaty interpretation would not even be aware of. So the practical utility of learning more about the activity of treaty interpretation so as to become a better practitioner is what has inspired the reflections that I'm just about to share with you. Now, you may find my way of presenting my thoughts a little bit unconventional, for a law audience. I don't have a claim. We spoke about this afternoon with James, as is customary to say in US academic parlance, let alone defend any such claim at all costs, trying to outwit my interlocutors. I believe this has never been the way in which I have conceived my work, my job as an academic. I try to provide food for thought, to spur further reflections on international legal processes, and possibly in an intellectually honest way, accounting for them. I suspect there is an ulterior motive in my choice of using unconventional means to communicate my thoughts, certainly not attuned to the orthodoxy of the discipline. I hope that by hearing and by training the ear to listen to different tunes, it could become easier at some point to think of all problems in a different, more creative way. So after this long and I hope useful prolegomena or preliminary remarks, let me proceed and share with you my musings, actually 6 musings. And the first is this: rules of interpretation are not directly conducive to the meaning of treaty provisions. Lawyers are enchanted by rules. We work with and through them. Our arguments and our claims are all based on them. In many ways, rules are the universe that lawyers inhabit. Our professional mindset is calibrated to work on this basis. They have become some sort of second skin for us. We are inhabited by them, and we no longer realize that we are actually ruled by the rules we try to use. The allegation that international lawyers have come to be obsessed with the Vienna rules on treaty interpretation is hardly contestable contention. There is practically no judgment, no argument by counsel, no scholarly piece, and no student exam dealing with treaty interpretation that does not begin and end with the Vienna Convention on the law of treaty arguments. To dispense with the Vienna Convention rules would be akin to mentioning the 1986 World Cup match between England and Argentina without mentioning the goal scored by Maradona, or to think of Harry Potter without visualizing its magic wand or impersonating actor Daniel Radcliffe's round bespectacled face is just not possible. In international law, when we think about treaty interpretation, we typically adopt a how to interpret kind of mindset that orients us immediately to the rules of treaty interpretation. And we entertain the illusion that the Vienna Convention rules of treaty interpretation, if correctly applied, are conducive to meaning. And that, provided one masters the rules, there can be no doubt that they will get the meaning right. And this posture is entrenched in the profession and is hardly ever called into question. Now, this is precisely what I would like to do with my first musing, that is to challenge and reconsider this widely held assumption and to inquire afresh about the role and function of rules in treaty interpretation. And to do so, I will have recourse to a debate that has occurred in philosophy concerning the role of rules in defining an activity, an institution, or any social practice. In particular, Hubert Schweitzer took issue with the widely held conviction among philosophers that language is determined and defined by a set of rules that allow us to grasp the meaning of the speech acts we perform. And according to the conventional philosophical view, activities and practices can be seen as systems of rules, and the rules actually define them. So are games such as the game of chess. According to some, the rules that the bishop moves diagonally, that the rook moves vertically or horizontally, and all the other rules that determine how the pieces can be moved on the chessboard constitute the game of chess. If the queen were not allowed to move freely on the chessboard, or if a pawn could advance 3 squares, we might conclude that we are no longer playing a chess game. And this is why we believe somewhat simplistically that the rules define the game, and that, as John Searle contends, the activity of playing chess is constituted by action in accordance with these rules. But the point about the role of rules is illustrated by a compelling example. Please bear with me for a moment. Schweitzer asks one to imagine a visitor to the fictitious country of Ruritania, who happens upon a group of people sitting in a circle on the floor and speaking to one another. And in the middle of the room, there is a small table with a chessboard and pieces arranged on it as if a chess game were about to start. And after some time, two men in elaborate clothes enter the room and stand on the two sides of the table. And they start moving the pieces on the chessboard according to the rules of chess. They start rolling the pieces, they concentrate closely on the actions they perform. They do not seem to follow any of the known strategies that are used for the game of chess. And after a while, when the white checkmates black, everyone seems relieved and starts congratulating one another. Rather puzzled at what he saw, the person visiting the Ruritanians was convinced that she had watched a chess match. However unconventional the attitudes of the players. But later in the day, she takes a chessboard out of her backpack and invites her Ruritanian friend to play the game. And her friend reacts with disdain, accusing her of blasphemy for wanting to play chess and for having presumably forged the chessboard. And after a rather heated exchange, the misunderstanding is cleared up. In fact, in Ruritania, each community has only one chess set, which is used for divinatory purposes. If white checkmates black, crops will flourish and the community will thrive. If black mates white, the opposite will occur. The whole process is a sacred right and no game at all. No one wins or loses. Chess is not a competitive contest. The expression "let's play chess" carries no meaning whatsoever in Ruritania, and the Ruritanian priests moving pieces on the chessboard by the rules of what we know as the game of chess do not intend to play a game. They only want to find out the will of the gods. So what distinguishes the Ruritanian rite of chess from our game of chess does not lie so much in what goes on the chessboard, on how the pieces get moved on it, but rather in the role that the activity in question plays in the lives of those who perform it and for whom it is a practice. What playing chess means is not explained by the rules. Playing chess does not consist in acting in accordance with the rules. The rules of the practice do not tell us what practice is or which they are the rules. Schweitzer convincingly argues that rules do not and cannot define the nature of an activity, and that the rules of chess, for example, do not explicate what is to play chess. And by the same token, I should say, rules of treaty interpretation do not define the nature of the activity of treaty interpretation, and that these rules do not explain what it is that we do when interpret a treaty. If to interpret a treaty provision or any other legal text implies attributing a meaning to it, this meaning can only be inferred or derived by a social practice. And no social practice is captured solely by the rules. Ludwig Wittgenstein famously expressed skepticism about the role of rules in determining meaning and in ensuring stability and consistency of meaning by showing that knowledge of rules does not imply knowing how to use and to follow them. Wittgenstein paved the way for reassessing the role of rules in language and social intercourse. And in particular, he maintained that the correct use of language is determined not by formal rules, but by its use, and the fact that rules are followed and obeyed is nothing but a social practice. Wittgenstein's intuitions and findings are particularly relevant to our understanding of treaty interpretation. Rules alone cannot ensure the stability and predictability of meaning. They are embedded in practices where obedience depends on there being a practice followed by a social group in a given form of life. In other words, they provide a grammar, which according to Wittgenstein represents the normative structure for giving meaning to language, for telling what an object is, and for determining what language move makes sense in any given form of life. Likewise, in the field of treaty interpretation, the rules in the Vienna Convention could be regarded as the grammar, the scaffolding, or the common discipline that can be used not so much to get directly to the meaning, but to establish what means can be used for determining that meaning in international law. A practice such as treaty interpretation can never be defined or exhausted by the formalized rules designed to regulate it. It is also defined by a series of informal conventions governing the relevant actors' attitudes towards it and determining what they consider to be permissible or appropriate things to do when they engage in such a practice. And this is the reason why the practice of treaty interpretation, while not defined by rules, can never allow for some sort of anything goes. Such conventions limit the choice that interpreters make and render treaty interpretation a constrained activity. Now, let's move to the second musing, which is this. Plain or ordinary meaning is not to be found in the text and therefore cannot be extracted from it. The official interpretive discourse remains strictly focused on the primacy of the text, at least for international lawyers. The ordinary meaning to be attributed to the terms of a treaty is considered a primary interpretive tool. The idea that words have a plain meaning is widely shared among international lawyers. It suffices cast a quick glance at international case law to realize that resort to language dictionaries is fairly frequent in the practice of international tribunals, so much so that it's frequently used by the WTO dispute settlement body because one of its former members, to speak of the shorter Oxford Dictionary, as one of the WTO covered agreements. Now, as is well known, the interpretive techniques of textual reference and plain meaning were instrumental for the office of the legal counsel at the US Department of Justice to provide a definition of torture, which would allow US officials to use highly coercive techniques of interrogation vis-a-vis terrorist suspects. In the notorious Bybee memo, named after one John Bybee, who was an attorney working at the time for the office of the legal counsel, the interpretation of the term torture had to be carried out in light of its plain meaning. And how did he get there? Well, he get there first by identifying what are the core elements of the definition of torture, namely severe physical or mental pain or suffering. So the key was to establish what severe plain meaning actually was. And after referring to a couple of definitions and entries in dictionaries, the focus shifted from dictionaries to statutory sources without apparent reason, but always with the goal of spotting the plain meaning of the adjective severe. And John Bybee ended up analyzing the other US statutes in which the expression severe suffering appeared. And what he ended up with were statutes defining an emergency medical condition, where the expression severe pain referred to damage that rises, and I quote, to death, organ failure, or the permanent impairment of the significant body function. So the plain meaning of severe pain was thus equated to death, organ failure, or permanent impairment of a significant body function, short of which there was no torture. And this allowed the use of so-called enhanced interrogation techniques in the name of plain meaning of the expression severe pain or suffering. A few illustrations from actual practice may help shed light on the limits of plain meaning and provide its most fervent supporters with some food for thought. In a case which has been made famous by critics of the doctrine of plain meaning, a district court in the US had to pass judgment in a suit concerning the sale of chicken by an American retailer to a Swiss company. And the latter complained that the kind of chicken delivered to it was not what it expected. In particular, the Swiss company maintained that according to commercial usages, the word chicken had a precise meaning, fryers or roasters, which did not correspond to what it had actually got, stewing chicken or fowl. And the American company in turn argued that its interpretation of the word chicken as it appeared in the contract would also cover the animals it had actually delivered. And the judge then famously asked the question, black and white, in his judgment, so what is chicken? And in order to answer this plain meaning question, he summoned the operator of a chicken eviscerating plant in New Jersey, who provided expertise, and he said, chicken is chicken, but then you have to make a distinction, you have to specify which category you want or that you are talking about. International lawyers too can offer some examples of the distorted or misleading use of plain meaning. One example was given by Lord McNair in his famous 1963 treatise on the law of treaties. And Lord McNair reported the case concerning the will of a man who had left everything he possessed to mother. And he wrote unambiguously in his will, all for mother. Interestingly enough, the whole heritage was attributed to the man's widow, his wife, who was referred to by all members of the family as mother. So these examples are interesting as they show that words as such are neither clear nor ambiguous. After all, such words as chicken and mother hardly present any lexical ambiguity, do they? As McNair put it, no term could be plainer than mother, for a man can only one have mother. In fact, what makes the meaning of a word plain, clear, or unambiguous is not any linguistic property the word may have, but rather the context in which it is used and the code used for communication in a particular situation for a particular community. In other words, as Kai and Herman once put it, it's not that the meaning is not controversial because the text is clear. Rather, the opposite is true. The text is clear because it is uncontested and therefore uncontroversial. Now, the above remarks notwithstanding, I'm not arguing that a given text may not have a clear and ordinary meaning or a meaning that goes without saying. What I call into question is the proposition that this comes from some intrinsic language, linguistic properties of the text itself. In fact, plain meaning is not the product of linguistic analysis, but rather of context broadly understood. An apt illustration of the importance of context is given by a linguist, Garrett, who uses as an example the statement, the boy chased a dog with a car. In interpreting this statement, we presuppose that the boy makes use of the car to chase the dog. It is highly unlikely for any one of us to think that the dog which the boy is chasing has a car. And yet nothing in the grammatical structure of the phrase compels that conclusion. We think that the boy rather than the dog has a car because of our experience and knowledge of the empirical world. By the same token as the statement to be interpreted where the boy chased the dog with a bone, we will presuppose that the dog rather than the boy has a bone in its mouth. But our conclusion is mandated not so much by the plain meaning of words, but by what we know about dogs and boys, by context and the empirical world. And to insist on this particular point seems all the more necessary, as most of the time the plain meaning of a text presents itself as self-evident, and as such it seems to require no interpretation. But if the literal plain meaning of a text is so readily comprehensible to us, regardless of context, this is so because the interpretive act that we carry out is so deeply embedded in the societal and in contextual setting that we do not perceive of it as an interpretive act at all. In other words, the context is so deeply assumed that it becomes invisible to the observer. Let me now move to the third musing, which has to do with the genealogy of the contemporary regime of treaty interpretation. Now, the way in which we look at the history of legal regimes, institutions, or even individual rules depends to a large extent on the theoretical and cultural presupposition that direct our gaze. What we see is a direct function of what our eyes can see or have been trained to see or not to see. In searching for the rationale of the rule or the origins or evolution of a policy or legal regime of a time, our natural instinct is to rely on the official history. And this type of official history has particular characteristics. It tends to focus on the idea that the development of a legal regime is a linear one, It tends to emphasize institutional dimensions, that the expansive, the flesh and blood individuals who took part in these processes, and in particular, often apparently insignificant events that mark major turning points, shifts, or ruptures, and that frequently go unnoticed in traditional historical accounts. Official histories continue to be taught to according to traditional wisdom and disciplinary knowledge, and they are consolidated in socially accepted market and post textbooks that continue to reproduce them, and that's how we learn about things. But the representation of the history of legal rules and institutions as a linear development is readily recognizable when it comes to the Vienna Convention regime on treaty interpretation. The idea that codification represents the culmination of a historical process, whereby scattered maxims of interpretation develop into consistent practices and clearly enunciated principles in the works of the fathers of international law, which then become legally binding rules, codified and universally approved in a widely shared account. And this sentimental assumption that what we value, regardless of the reasons, must have had an origins, or which we would also prove, is a very human reflex, isn't it? After all, the myth of origin and the notion of progress serve the purpose of having us believe that the present rests upon profound intentions and immutable necessities. Truth be told, this is not the only way one could look at the history of the emergence and subsequent development of the international legal regime of treaty interpretation. An alternative way of looking at it might be through the prism of the concept of genealogy. In a very interesting piece, Michel Foucault examines the notion of genealogy in light of Nietzsche's philosophy and further develops the concept on his own. Foucault contrasts the history of historians that finds its support outside of time and pretends to base its judgments on apocalyptic objectivity to a genealogical approach, whereby the forces operating in history are also not controlled by destiny or regulatory mechanisms that respond to haphazard conflict. The notion of history as a profusion of entangled events gives priority to searching for the singularity of events, sometimes in unexpected places. A genealogical inquiry is the exact opposite of what I call tracing a pedigree. Genealogy seeks out discontinuities and ruptures in history rather than evolution and progress. The genealogist is more interested in accidents and fortuitous events than fabricated patterns of uniformity and consistency. And in fact, a genealogical approach to the development of the current regime of treaty interpretation reveals a fairly different story from the so-called official history. In fact, interest on rules of treaty interpretation can be traced back to the 1950s, when the matter of treaty interpretation was taken up by the International Law Institute, the Institut de Droit International, which is a professional association, which was probably a little bit more prestigious at the time than it is now, but yet was at the time one of those bodies that promoted the codification of international law. And the task of being the rapporteur for the Institut de Droit International was attributed to Hersch Lauterbach in the 1950s, who presented a very substantial report on treaty interpretation, saying that, you know, the only one thing that matters when you have to interpret a treaty is to reconstruct the will of the parties. So you don't need any rules, you just have to find out what the parties intended, and for this purpose, preparatory works are particularly important. So this approach generated some debate, but Lauterbach was a highly eminent jurist, so he had chances of pulling this through. And in fact, he proposed a resolution first in Bath in 1950, and then in Siena and Aix-en-Provence in 1953. And then, as is often the case, a change in material circumstances and happenstance played a role in the subsequent shift of focus of the Institute's project and in determining who the winner was. Lauterbach was elected to the ICJ, so he didn't have any time anymore for the Institute. And his designated successor, Lord McNair, was indisposed. So Sir Joe Fitzmaurice took over, which is a product of happenstance. And General Fitzmaurice was the staunchest opponent to that attitude, and he was a strenuous defender of the British tradition of textualism. And so in 1956, and in a blink of an eye, he was able to reverse completely the trend and propose a very short resolution made of just 2 articles, in which ordinary meaning was, the main reference. The text was the primary reference. The text and its ordinary and natural meaning. And then he said, if there is the need for something else, international courts and tribunals will continue to do what they have been doing, for centuries, applying maxima of Roman law, elaborated by grammarians or logicians, and that was it. And this is not to be underestimated, because in fact, the 1956 Grenada Resolution formed the basis for the subsequent work of the International Law Commission on the matter of interpretation of treaties. And to make a long story short, I think that turning point in which Lauterbach was no longer able to participate and lead the discussion, and Fitzmaurice took responsibility, marked the beginning of the success of the British tradition of textualism, particularly because during the works of the International Law Commission in the 1960s, another British scholar took responsibility as rapporteur, Sir Humphrey Waldo, who actually confirmed this approach also in the final draft articles of the International Law Commission. And eventually at the Vienna Conference, there were very few dissonant voices on the matter of interpretation of treaties. A notable exception was the American delegation, led by Miles McDougall, who had a completely different vision of interpretation of treaties, who more wanted to promote a holistic approach, and who had suggested to merge what are now Articles 31 and Article 32. He was defeated very badly, and the amendment was rejected by an overwhelming majority of votes. But one anecdote, which I think should make us all reflect. Miles McDougall at some point told the plenary at the Vienna Convention, at the Vienna Conference, okay, so if text is the only thing that matters, could you tell me why Sir Humphrey Waldo, whom we have invited here as an expert consultant, because he was the special rapporteur for the International Commission, we always ask questions to him about what did actually the IOC mean when they wrote this and that. So I think it was quite a powerful argument. If textualism is self-sufficient, Sir Humphrey Waldo should have not been summoned at the Vienna Conference. The gist of this short story is that what we take nowadays as an uncontroversial and something that goes without saying, the Vienna Convention rules on treaty interpretation, was far from being considered as such until recently. And to highlight the contingency of some of the events marking the codification process, it's not meant to lead to any relativism of sorts. There is no denying that there is social consensus that these are the instruments to be used now for the purposes of interpretation. Their historicity and contingent character, however, need to be stressed in order to avoid attributing to them an ineluctability that they do not possess and that they were never meant to possess. Still using the metaphor of the game. When Stanley Fish notoriously stated that interpretation is the only game in town, most legal commentators focused on the consequences of conceiving law as interpretation. But the term game was completely overlooked. And this is the reason why I would like to examine interpretation, the process of interpretation as a game, while leaving on the background the philosophical question of whether law as such is only interpretation. Certainly the game as a metaphor, and as such it helps to capture the essential traits of a concept or an activity, the contours of which might be difficult to define with any accuracy otherwise. And the metaphor of the game, I thought it was an apt one because it contains all the elements that characterize the interpretive process. There are players who are engaged in the game and who are supposed to interpret the law. The rules of play are known and complied with by the players, even though which cards to play and when is left to the skills and to strategies of the individual players. And quite obviously, the game has an object. So let's now have a look at the game's instruction fit. Let's start from the object. The ultimate object of the game of interpretation is to win, namely to persuade one's audience that their own interpretation of the law is the correct one. In other words, the winner is he or she who succeeds in securing adherence to his or her own interpretation. The recreational character of the game of interpretation should not be overstated. In fact, most of the time, this is a highly competitive contest in which the stakes are high and the battle to impose one's interpretation is fiercely and ruthlessly fought. As to the players, I suppose they will certainly include states and international organizations, or more accurately, the individuals who work for them, courts, both international and domestic, non-governmental organizations, professional associations, practitioners working as counsel, advocates or experts in international law cases, academics working on interpretive issues or general theory. So with a little malice, but with practically no risk of being proved wrong, one could also add to the list clerks and assistants who help judges and arbitrators draft their judicial opinions, and arbitral awards and research assistants who help academics write their books and articles. So there is myriad of different players. No accreditation is demanded of players, but not everyone's voice weighs the same. Not everyone's view matters in an egalitarian term. For instance, international lawyers attribute an enormous importance to judicial interpretations. It suffices to think of how we analyze judicial decisions, particularly those rendered by particularly authoritative judicial bodies such as the ICJ. Robert Jevons aptly noticed that the judgments of the court tend to be considered by international lawyers as holy writs. Single lines and often single words are dissected, analyzed, and often used completely out of context as evidence of any given interpretation of the law. It should be stressed once again that the game is far from being peaceful. It may be worth recalling that etymologically in Latin, ludus, the word for games, refers both to the game as well as to the enclosure or school where the gladiators were trained to fight. It's the same word. Indeed, players may get aggressive and misbehave. They certainly are unruly most of the time. They wear different hats in their professional career. Sometimes at the same time, by performing different roles, they hope to increase their capacity to impact the game. It is notorious that academics often act as advocates and counsel before tribunals or give their opinions in other contentious settings, or are appointed as judges or arbitrators. The contrary is also true. Practitioners are often the beneficiaries of academic appointments, or they serve in capacities that once were exclusively reserved for academics, like membership of law journal editorial boards or academic search committees. Now, continuing with the metaphor of the games, what are the cards that are being played in the game? Well, this is perhaps the easiest part of the rules of play to go through, as what the cards are is a relatively uncontroversial issue. The cards are mostly, but not exclusively, those contained in the Vienna Convention and the law treaties: ordinary meaning, good faith, object and purpose, context, subsequent practice, subsequent agreements, other rules of international law applicable between the parties. There are some slight variations to the game. One can do additional cards from general principles of law, lex specialis, the principle of effectiveness, and myriad other maxims or principles, most of which require a translation from Latin. But such an unconditional success of the cards is hardly surprising, as the flexibility of the system is such that recourse to the Vienna Convention accommodates practically all approaches to interpretation. The principles and rules of the Vienna Convention can be twisted, bent, turned upside down, the criteria codified, and it can be prioritized to one's liking. So, like in any game, strategies are also important. The way in which a player is capable of effectively addressing the audience by capturing its attention and by leading it through his or her line of argumentation will depend on a variety of different factors, ranging from the authority of the player to his or her rhetorical skills, to the receptivity and disposition of the audience. And in fact, the importance of rhetorical tools and techniques in establishing interpretive strategies ought not to be underestimated. Tricks or interpretive devices, well accepted in the profession, can be used to channel interpretation in one direction rather than another. Just one example of it, the general rule exception paradigm. In a situation in which the state of the law is uncertain, to decide to adopt a certain rule as a general rule may have dire consequences. Most of all, this may cause a shift in the burden of truth for whoever is to argue that an exception to a general rule has emerged. So finally, to conclude on the metaphor of the game, one may well wonder why the players are, or at least give the impression of being, so little aware of the strategies they use, and act as if they were not playing the game or implementing a strategy. Well, the reason for this most likely lies in the constant process of socialization. That's how we are trained. That's how we are socialized into the business of interpretation. This is what causes certain moves or reflexes to consolidate over time and to become a habitus of sorts, which is interiorized by the players and then becomes a natural attitude for the players participating in the game. So the fifth, last but one, musing, the social dimension of the interpretive process. At this point, one may wonder, how can the formation of meaning be explained? In fact, at the origin of meaning, there is always a social community. Only within a community is communication possible, and acts come to acquire a certain shared meaning. And this contention, developed by different philosophers, must be the starting point for any attempt to investigate the origin of meaning, even in law. The continuous interaction of a social group in any given societal context determines the background against which meaning is formed. To emphasize the communitarian dimension of the interpretive process is no novelty. Some distinguished philosophers, such as Royce and Peirce, put forward this contention long ago. Royce developed in his work on Christian religion the notion that the real world cannot be conceived outside the interpretive community that provides it with a meaning which is common to the members of the community. And along the same lines, Peirce maintained that the concept of reality essentially involves the notion of community, and that the opinion which is fated to be ultimately agreed to by all who investigate it is what we mean by the truth, and the object represented in this opinion is the real. According to Umberto Eco, in Peirce's theory, the community transcends the intention of the single interpreter, and from the moment in which the community is proved to agree with a given interpretation, there is, if not an objective, at least an intersubjective meaning which acquires privilege over any other possible interpretation spelled out without the agreement of the community. And the very notion of interpretive community, as you may well know, has been elaborated in great detail by Stanley Fish in the field of literary studies. As is well known, Fish used the concept of interpretive community to solve the riddle of the authority of interpretation by shifting the focus from the text and the author as the alternative source of authority to the social dynamic of the community of interpreters. Fish dramatically changed the fundamental paradigms of traditional legal interpretation theories and broke new grounds for the investigation on the origin of meaning. According to him, interpretive communities are made up of those who share interpretive strategies for reading and for writing text, for constituting their properties and assigning their intention. And to attempt to provide an interpretation of texts, including legal ones, on the basis of the notion of interpretive community is not tantamount to denying the authority of interpretation. It simply shifts the focus from the text itself to the actors concerned with its interpretation. This process does not imply at all that any interpretation is admissible. it certainly is not an instrument to foster some sort of interpretive anything goes. As there may well be interpretations that are utterly inadmissible because the interpretive communities do not conceive of them as legitimate interpretations. And in this respect, I think it's worth underscoring that interpretive community theory provides no epistemological foundation for a theory of meaning. In other words, it is not a theory that aims to explain what a text means. Its main value lies rather in providing a sociological explanation of how different readings of a text emerge and through what process they become eligible for being considered as the correct interpretation of the text. My point is that at the original meaning is always a social community. The continuous interaction of a social group in any given societal context determines the background against which meaning is formed. And the idea that any act of interpretation of whatever nature is embedded in a complex web of social relations is slightly reminiscent of Wittgenstein's notion of forms of life. According to Wittgenstein, our acts, our gestures, our words acquire their meaning only against the background of the form of life in which we are set and the practices carried out therein. So let me move to my last musing, for which I have no precise title, sorry, James, which I would call it unappealingly a broader reflection on meaning, if I may. My last musing does not have much to do with international law technicalities and treaty interpretation. In fact, our quest for meaning is not limited to legal text, is it? Nowadays, international lawyers more and more search for meaning in their own profession, the meaning of the profession we have undertaken, the meaning of our own way of performing our job. What does it mean, or what should it mean to be an international lawyer in today's world? Not an easy question. I honestly do not know how often international lawyers ask themselves the question, but I think it is a healthy one. It is a healthy reflex to wonder with some regularity, was it sense of what we do and the way in which we do it. Be it treaty interpretation or something else. To infuse a sense of purpose into what we do is a promising start, I think, to have a more aware, if not rewarding, professional experience. I suspect that in contemporary society, widespread expectation among those who undertake the legal profession is to acquire wealth and social visibility and consequently power. I don't mean that this is not a legitimate expectation, yet it seems to me that these goals ought not to be the ultimate meaning of the profession. Their instrumental character is such that neither wealth and social visibility nor power can be regarded as ends in themselves. They rather ought to be considered instruments to achieve other goals, other purposes. It's not that they do not have meaning, of course, they do, but would one really wish that the reason why they become international lawyers is only because they want to make money? There would be many more lucrative activities that are probably even more handy and easier than the option. Or social visibility, why not turning into a YouTube influencer? Or turn into politics if it's power is what you want. Emmanuel Macron, the president of France, was elected. He was only 39, and his last but one prime minister was only 33. So yet another meaning often put forward by international lawyers to explain their choices, to find meaning in what they do, is to save the world, or at a lower level of ambition to enhance the well-being of humanity. Now, this is an admirable task and widely shared in the profession. At closer scrutiny, however, the righteous nature of the enterprise could be called into question. How about if the world does not want to be saved? And even if it does, it may not want to be saved by you or by the means you want to use. This may solicit laughter, but it's an interesting point, I think, to raise. Strong convictions about what international law is or should be about can also provide meaning to what we do. It is not infrequent to find international lawyers that are strongly committed to preserving the current state-centered system, its values and institutional structures. Some other international lawyers find meaning in and take inspiration from the transformative potential of international law. They're convinced that international law is a force for good and the instrument by which global challenges can be tackled and eventually solved. International law is a secular faith in the capacity of humanity to redeem itself and to realize higher goals. Yet others, deeply skeptical of all of the above, find meaning in unearthing the allegedly flawed premises of the system and its accompanying official discourse. Critical legal theories highlight the many false necessities present in international law, its principles and rules that seem obvious and that seem to go without saying, but in fact, they are far from being obvious as they are the product of political choices. Luckily, the profession nowadays is variegated enough to accommodate all these different points of view, all the various purposes we have analyzed above. One may have their own preferences and pursue their own goals, but once again, meaning is inscribed in a collective fabric. The solitary pursuit of an individual mission would hardly give them any meaning to one's life. Oh my, here I finally got to utter the words I meant and promised myself to stay away from, the meaning of life. The last bit of the last musing is that lawyers are not the only one category of human beings who search for meaning. We all are. I knew this was the ultimate danger of proposing a topic like this for the lecture. How can we possibly talk about meaning without addressing the meaning? The one we try to pursue for all our lives, or sometimes the one we desperately attempt to avoid for all our lives, being just scared not to find one. Each and every one of us every day experiences questioning about the meaning of life. How many acquaintances, friends, and even family members of ours every day complain about their quality of life, lack of purpose, and happiness, clearly show signs that they have lost direction, they lack point, that their life has hardly any substance, that they would rather go after other things, explore new avenues, treasure other values. I'm sure we all can think of plenty of examples along these lines. A sense of lacking of life, meaning too little. And it's exposed to the opposite phenomenon. People finding meaning in all they do. Their job is fantastic. So is their yoga teacher and their children and their car, let alone their new house. Incidentally, one may notice that this is primarily the wealthy who tend to feel more often than not a sense of achievement. Yet they do not seem particularly happy, don't they? But that's another story for another day. The fact remains that for some of these people, there is almost too much meaning in life. So why is it then that there is either too little or too much meaning to life? Why are we so confused about it? Why do we seem to mix apples and oranges and feel either replete with meaning or societally deprived of any? I suppose one can think of reasons for this state of affairs. It was probably easier when societies were more religious. Religion is a powerful antidote to lack of purpose and direction. Religions provide reasons for living, also for dying. They provide meaning to their followers, examples to live up to in terms of behavior, a set of beliefs to conform to and live by, the possibility of finding meaning or finding a reason to live, regardless of any preordained divine design, would be seen as an accomplishment of modernity. Such an accomplishment would allegedly consist of being able to freely determine ourselves what the meaning of life is. But then lately came postmodernism that brutally dispelled any remaining illusion that there could be a meaning of meaning, a grand design for life common to all. What out there may seem as coherent and meaningful is actually not the way it looks. It has to be deconstructed and constantly rethought and reenacted. Difference is what matters and not what we have in common. There's little space remaining for thinking that there may be a meaning of life that goes beyond individual inclinations and desire. But how if the meaning of life were not some goals to be pursued by individuals, some choose to be revealed, but rather life in itself, or perhaps a certain way of life? This is the question that Terry Eagleton asks in his wonderfully written, a very short introduction to the meaning of life. What if meaning were relational? That's the way in which we talked about it earlier in relation to treaty interpretation. What if rather than consisting of something we are, or we aspire to become, the meaning of life lay in how we live in relation to others? Meaning of life merchants, Eagleton argues, generally feel let down by such a claim, since it does not seem mysterious or majestic enough that the meaning of life can turn out to be embarrassing or resigned. A matter of feeding the hungry, giving drink to the thirsty, welcoming the stranger. Happiness does not have to do with some beaming or divine contentment, but the condition of well-being which springs from the free flourishing of one's powers and capacities in harmony with the community. And I believe that this image of the flourishing of the individual coming about through the flourishing of others is an awesome way of looking at the meaning of life. Life is about being connected, not just rationally, let alone digitally, but emotionally to the world all around us. That's where the meaning of life is spelled out every day in mere different forms. It should be good to have a life in which we are aware of what we do and why. And we are considerate of others, a life in which there is always time for the other, because time is what you choose to make of it. A life of compassion for and empathy with others, a life in which own sense of fulfillment and well-being is related to that of others, a life in which you never forget to smile, to help, to care, to make a gesture toward the other. Not just a life that has meaning, but a way of life which in and of itself is meaning. And if I were to play with words, I should conclude, and I do conclude by saying that it's always a form of life and a social practice that are needed to give meaning to treaty provisions, to our profession, and to our life too. Thank you very much.
I'll use my power as the chair and ask a question. It's really a reaction, I think, that will turn into a question, I hope. But wow, right? Wow. Big picture, big themes, wonderful. I was teleported back to about 19 years, in fact, 19 years to this day. I was in here to this very day, I was sitting in his state responsibility class. For the past, to start my PhD, at that time, Ashi started in late October, if you remember. Right, so this was the beginning of the semester. And I had spent the past 6 months, I had been admitted to the PhD program, and I was telling all of my friends, oh, I'm going to do my PhD at the Graduate Institute. And they all said, who were international lawyers, they said, oh, it's a very legal positivist world. They care about observation and about treaties and not very interesting, right? And then, so I thought for 6 months, oh no, did I make the wrong choice? And then this was my very first class. Can you believe that, right? And here I was sitting, relieved that I made the right decision because I wanted to get deeper. I went to Europe because I wanted legal theory. I wanted depth, which I couldn't get in Europe, in the US or elsewhere in Europe. The very first topic was, and I actually went through my notes the other day. I use this as an excuse to go through my notes. One of your main theses for your first class was that the special rapporteur for the articles on state responsibility determined how that draft was accepted by member states. This was his thesis, and he went through each of the special rapporteurs and tried to explain how these individuals had an influence on the creation of law. I was so happy because this went to my core. As an American, I like American literature. I study what's called realism. So John Updike, if you're familiar with that sort of tradition with literature, I love it. And the legal tradition of legal realism, of looking past the veneer and pulling away the curtain and seeing behind how laws are created, right? I wanted that. And I thought for those 6 months, I wasn't going to get it. And then I got this, right? So I feel very right now. I hope you forgive me, but this speech was actually very important to me because from that very lecture that you gave, I've constantly wondered what your theoretical view is. Okay, very clearly not legal positivism, right? I'm a legal realist. I always wanted to think it was legal realism, but yeah, he doesn't check the boxes for legal realism. I'm familiar with David Kennedy and this critical legal studies. And if you listen to David Kennedy, he will go through these same examples. And the main difference between you and him, from my perspective, is David Kennedy at the end goes like this. I don't know. I don't really care. And he walks out of the room, right? But that's not what we get with Professor Bianchi. We have this hope, right? That rules don't matter, that international law doesn't matter, and yet he still cares about international law. And yet there's still this promise of an ordered society based on law. It's fascinating how you take me on this roller coaster from the very beginning. And I hope you're not offended by me trying to pigeonhole you and trying to understand what your philosophy is. So my question, tonight you gave me a hint of what your philosophy is. And I think it's when you were talking about the interpretive community theory and the social background of rules. And I started to think, okay, this is closer to Marty Koskoniemi, kind of looking at community interests and using this as a type of tool for interpretation. And I don't know if I'm fair in categorizing you that way, and I would welcome you to respond to that. But as a legal realist, I would ask, why don't you care more about who's interpreting? This whole lecture, I was thinking, you started to talk about Fitzmaurice, Gerald Fitzmaurice, and you were talking about, Hirsch Lauterpacht and all these great players. And that's what I start to get excited about when I start to hear those stories about how these individuals influenced the process. Why doesn't it matter in your mind who's doing the interpreting? When you were talking about individuals, it was the making of the rules. But at no point do you say that the person, whether it's James, whether it's Andrea, is interpreting the rule, whether that matters. I would, as a legal realist, I would love for you to get to that point, and you never do. And so in a way, it's teasing me a bit. I'm wanting to be on your team. I can't figure out what your team is, which I love. This wondering what your philosophy is with international law. I think it's very clear. It's deep, and it's profound, and it's trying to see how law meets reality, and that's the beauty of your approach. But I'm wondering if you could just react a bit, and I don't mean to put you on the point on the spot and say, what is your belief about international law? I think that's your beauty of being mysterious. But if you could enlighten me on if I'm fair in saying Marty Koskoniemi is closer to what you believe in than, say, David Kennedy or those others.
I don't know.
Okay. The perfect answer.
I don't know. I mean, it's tough for me to answer this question because, I clearly am who I am, and I'm the result of my own education, upbringing. Incidentally, I was trained in a highly positivistic environment. So I was trained to believe that international law, that's what it is, and there's nothing to think about it. And so I suppose it's intellectual curiosity that drew me away from the main path of the mainstream. And I started reading outside meaning other branches of the law, or even outside other disciplines. And I would take everything that helped me understand what I, as an international lawyer, do. So I look at myself surely as an international lawyer. I am not a philosopher, I'm not a sociologist, I'm not an anthropologist. I am not any of this. And I would like to talk to my fellow internationals, which sometimes is not easy. But I think that my main drive is to spur curiosity and interest in different ways of looking at things. One of the projects that I hold most dear in my career is this book I wrote on international law theories, which message is precisely, don't bother with what I think. Just get interested in all these different ways of thinking about international law. So I actually don't know. I think I'm a fairly unruly concoction of different influences at different times in my life. But if there is a common thread, that common thread is curiosity. And then, of course, each and every one of us have their own dispositions and inclinations and preferences, which I think they show in the way I speak, the questions I raise, and the way in which I deal with them. But I will not necessarily associate myself with Toscanemi or with David Kennedy. But interestingly enough, my students in international law theories, they hate me every week for a different reason. When I teach Marxism, they think I'm a Marxist. When I teach international law and economics, they think that I'm in law and economics. So it's so hard to take distance, right? And to reflect critically about what is it that we do it. And in the first page of the book on theories, I use this image that was used by an American intellectual in the commencement speech, Foster Wallace, who died prematurely, about the fish and the bowl. And the fish is in the bowl, and one day he bumps into another fish and says, "You know what? I spoke with the frog. Okay, so what? And you know what the frog said to me? That we live in water. Water? What is it? We are all fish in the water. So my only interest, honestly, intellectually, is that people are aware that we have water surrounding us. That what we do is, the product of certain theoretical presuppositions, methodological choices, and so on and so forth. And why it is so important to me, because I think that if we are aware of all this, I think that we will be more responsible as lawyers. Because lawyers have big responsibilities, they deal with serious things. So what I don't like is people who hide behind this kind of, oh, that's the law that says that. No, you interpret the law. So I am interested in who does interpret the law. I am even interested in who makes the law. Not tonight, but I've done it in another context. I co-authored a book on, co-edited a book on international laws and visible frames, social recognition and knowledge production processes, in which I engage with this idea. What are the forces, what are the epistemic forces that actually form the discourse about international law, from the way we understand international law and we practice it? So where does it come from? How is knowledge produced? How do we come to apprehend international law for what we think it is and for the way in which we use it? So no, I'm definitely interested in that. I think it's a fundamental question.
Okay, we'll turn the time over to the audience. Any questions? Yep, please go ahead.
So first of all, thank you so much for quite an amusing lecture. I actually particularly enjoyed the philosophical / existentialist touch that you put in, especially in your closing remarks. So my question, when I was thinking about your closing remarks, I was actually thinking about Albert Camus' Myth of Sisyphus. So my question is, are we constantly pushing our bullet up a hill and we watch it go down again ad idem? When we impose meanings deriving from contemporary ideals and objectivity as we strive to, as you said, quote unquote, win with the best interpretation? Because it seems to me that we're in a constant struggle between employing creativity in a sea of rules and conventions while wanting to come on top of it.
Can you say it again, because my hearing has gone very good? Can you say it again? Can you answer your question again, please?
Yeah, so are we trying to impose meaning with contemporary ideals and objectivity as we strive to win with the best interpretation? Do you think that there is a constant struggle in the field of treaty interpretation in international law?
Yeah, that's how there are two components of this that I find very attractive. One is the social embeddedness. I mean, meaning can only be generated in a community. And the generation of meaning through acts of interpretation is most of the time a contentious, if not violent process. And that's inherent in the nature of the law. We tend to project this ironic view of the law, being about justice, being about impartiality, neutrality. but law is violent, and its interpretation is violent too. So yes, I think that also the origin, I found it so amusing to realize that the word ludus also, which is the Latin word for game, also connoted the enclosures where the gladiators were trained to fight. Because that's what happens. And it's also my experience, both as an academic and a practitioner. That's what we do, we fight. James proposes his interpretation. I propose mine in opposition to his. Then you have to decide because you are the judge, or depending on the hat we wear, but we fight. We fight to secure the adherence.
It's quite absurd.
Sorry?
It's quite absurd in the existentialist meaning of things, I would say. Thank you.
Any other questions? Please, go ahead.
Hello, Professor. Thank you so much for the lecture. I just have a quick question. So, how do you define the progress in treaty interpretation? Like, what's the nature of when we're talking about we are making progress in this treaty interpretation?
How do we define what?
Progress, making progress in treaty interpretation.
Oh, making progress. I don't know. I think I spoke of progress in a specific context. So when we think of how we came about to the treaty regime that we use for interpreting treaties, we like to think that this is a line of progress. There was a time in which there were no rules. There was a time in which there were scattered attempts at using maxims, sayings or rules developed by grammarians. And then all of a sudden there was some kind of advancement towards the perfecting of the codification process. So there was a time in which was ripe for codification because everybody agreed that rules were what we needed, which is far away from the truth because until the 1960s, it was completely open whether or not we should have rules on truth interpretation. And international law had been interpreted until then by courts, tribunals, scholars, everyone. So, so I describe the word progress to describe a certain attitude that we all have to represent the origin of things and the development of legal rules and regimes as always advancing towards some, better state. It's like our very idea that was inculcated in us of international law has been primitive. What on earth does it mean? We are not primitive, we are different. Primitive implies simply that you will become better. And what does it mean to become better? To become more like domestic law. But if you want to understand the international law, you have to set it aside, you have to understand it for what it is. But we do have this idea, we always have this necessity to prove that there is always progress ahead of us. And that we do is, and the book I wrote itself to better treaty interpretation. I don't think so. I hope to give people food for thought, but I'm not convinced that it's a step in the making of a better regime of treaty interpretation.
Thank you. That's it, Professor. I just would like to give some kind of comment in relation to the question. Because I think in the discussion, you mentioned Professor Bianchi mentioned something about genealogy. And when the concept of genealogy is used, we are not actually talking about progress or the history of progress, but we are dealing with the history of ruptures. So there's something discontinuous here. And I think that's, I just want to point that out.
Yeah,
Thank
you know, of course, that it is absolutely crucial. And I was so struck when I found out, just out of curiosity, how this was this moment in the Institut de Droit International, in which Lauterbach was proposing the intention of the parties, no rules, we didn't care. And then the reason why there was the sudden change is because he was appointed to the court. And the other one wasn't feeling well, so he didn't show up. And the third person took over. And this was the size of moment. And it's so highly contingent. And that's the genealogy. Whereas if you look at the official history, you don't pay attention to these discontinuities, to these shifting points. You just think, okay, things do the droit national, and then it handed it over to the International Commission, and then the Vienna Conference, and then states accepted. It's all a linear progress of advancement. The genealogical inquiry doesn't look at things this way. It just points to, some interruptions, some odd things, some things in unexpected places that have occurred and that have played an enormous role. And I think, for instance, the fact that the US legal advisor to the US delegation in Vienna, Miles McDougall, was one of the causes for the hostility of most European delegations, because Miles McDougall was the founder of New Haven School. So he had very strong views, which were highly criticized. Fitzmaurice wrote a very nasty article in the American Journal by Victor's vow to the vanquished, very nasty against Miles McDougall after Miles McDougall was defeated in Vienna. It was personal. And these are elements that matter and that determine sometimes political outcomes and legal outcomes.
Other questions? Yeah, please.
Hi, thank you for the talk. My question is, perhaps you alluded to it, and I missed it, but what your take is with respect to when meanings conflict. So how would you conflict? How would you balance conflicting meanings? Would it be something like a Habermasian rational discourse theory, where even when meanings conflict, we can get to one common meaning, or meanings incommensurable? So at the end of the day, it's just an exercise of authority of which meaning is endorsed and adopted. Yeah.
I suppose, yeah. Interpretation is most of the time a contentious activity. So when you have different meanings, at some point one will prevail over the others. And it will prevail because there is some decision maker that at some point needs to settle, or because out of persuasion, you will win over your opponent and convince them that your interpretation is correct. But for me, it's not about truth and false claims or interpretation. It's not about right and incorrect interpretation. For me, all interpretations may have a certain degree of legal plausibility, and then they conflict with one another. And law is a very pragmatic exercise. At some point, a decision needs to be taken. And, traditionally, it's a decision maker of sort, which could be in our imagery, most of the time it's the judge, because we revere the judge. No, but it could be the foreign minister, the prime minister, the president. It could be an academic, whoever has the power and the authority to decide. At some point, meaning will prevail. And my interest is not so much, I'm not interested which meaning will prevail, but I'm interested in trying to capture what is this process of interpretation, how does it work? And to read, to get rid of this very simplistic idea that if we apply the rules of this interpretation, we get the meaning. I'm not sure that's it. Rules are important because they provide the grammar, structure, the means to get to the meaning. But then it's the process as a whole that you need to understand how it works if you want to be an effective player in the game of interpretation. That's at least my sense of it.
Okay, I'm conscious of the time, and I assume people who had to leave have already left, but I would like to give one last question to someone if there's a burning question. But maybe you can both give the questions and maybe they combine. So go ahead, please, and then Massimo, yeah.
I'm actually happy to give the floor to Massimo. Thank you so much. I really enjoyed this, and I've seen the six musing as your most of epistemological trajectory, in the sense that you have put forward different things in your career in different periods of time. And I wonder, like, of course, we are all child of our institutions. Like, I'm the child of Graduate Institute, and you are the child of Harvard and the French education to some extent of what I see you as working a lot on post-structuralism. And my question is like, at the end of the reflection, to what extent you think plurality plays in your thoughts? And plurality means your difference vis-a-vis other international bodies and the difference of different perspectives of law and legal theories generally. Do I get my question clear?
Can you make it clear? What is
Plurality, the role of plurality in
morality?
plurality,
Morality. Plurality.
plurality, multiple.
Yeah. Yeah. Sometimes I look at myself as a syncretist of sorts. It's taking things as I see them all, they come in handy. So pluralist, yeah, I think it fits at some point. Yeah, I think pluralism to me means to have the capacity to use different points of view, different tools. I like very much this idea that Foucault had of the toolkit. Said, I don't care whether you take my theories and you apply them the way in which I thought they should apply. But I'd be very happy if you consider what I have written, what I have thought, as some sort of toolkit from which you can pick up and choose and use whatever you want. So, yeah, I suppose that I have this vision of pluralism, perspectivism, if you like. Certainly, yeah, it's something that appeals to me because I am not convinced that there is some kind of truth or quintessential element in what we consider to be the law. It's a social process.
I figured it out.
So next week I'll be a Marxist.
Thank you. Last but not least, Massimo, please.
Thank you very much. So very quickly, I want to take you a step next to treaty interpretation and move on to customer international law for a moment. Two questions. Number one, do you think that one can interpret customer international law? And if yes, the musings that you set out for us tonight, do they also apply to the interpretation of custom, given that we don't have the same scaffolding, so to speak, or the Vienna rules for treaty interpretation? Thank you.
So I don't know, I haven't thought about it. My instinct would be not necessarily, because I take custom to be a different kettle of fish than treaties. It's not just because they're written or unwritten, but treaty interpretation as a history, as a development, as as some things that customary lawmaking processes probably do not possess. But I think that an interesting work, intellectual work can be done as regards custom by drawing from, things that people usually don't look at. Of this, I'm convinced. Whether you will find this useful for analyzing the interpretation of custom, I honestly don't know. I suspect certainly not all, maybe a few insights here and there. But I think there is a lot to be done because interpretation of custom and international law has been done in a very scholastic, simplistic way, very traditional way. So it's about time to try and frame it differently. And I'm sure that, the way in which interpretive theories have been used also in other disciplines might come in handy. But how and by what means, I suppose that's the next work you will present to us, isn't it? That's what you're working on, right? No? Yeah.
All right. Well, thank you very much for the questions. Thanks for your participation here. If you can join me in thanking Professor Bianchi.